Welcome back to With or Without Sugar. Here's a thought. So you have a company name you've registered. You've named your product accordingly. That gives you the right to trade under that name, doesn't it? Not necessarily so. If you haven't trademark protected that name, you may well be at risk of not being allowed to trade under it. We're here today with Shane and Tyrone Walker of Africa's leading intellectual property law firm, Moore Attorneys. Welcome to With or Without Sugar, chaps. Thanks for joining us. We're here at La Rosa Tequileria in Johannesburg. And that's where I'd like to start, because Shane, Tequileria would seem to me to be one of those names that we as brand professionals seek out because it's unusual, it's got a unique quality, and therefore is probably protectable as a trademark. Tell us a little bit about that.
Okay, so Tequileria, it's very much like, let's say if it's pizzeria, for instance. Pizzeria would be completely descriptive, it wouldn't be unique, and hence you couldn't protect it by way of a trademark. However, if we did a search, which we should always do prior to filing a trademark, and we picked up that Tequileria was in fact completely distinctive, a made-up word, and not used out there, then in fact we would protect it as a trademark, and you would have exclusive use of Tequileria to be able to stop anybody else using it.
Now Shane, you've got a brilliant example that I happen to know about. I'm going to press you for some detail about it on exactly that subject matter, which was when PG Glass were looking for uniqueness in the shatterproof name, and they tripped across a generic word being shatterproof, but you got them around. Tell us about that.
So they adopted shatterproof in something like 1936, so it's a very, very old trademark. They've got shatterproof PRUFE. However, the marketplace was using shatterproof PROOF, and they used to have a lot of radio adverts advertising their product, which they would say buy shatterproof windscreens. But in fact, they weren't distinguishing their windscreens from the rest of the market. So just a bit of playing around with words, they would then have a radio advert saying shatterproof, that's PRUFE, and hence distinguish their brand from the rest of the market. But it leads you to realize that when you're choosing a brand from the get-go, you should choose something that's highly distinctive and not something that in normal English words you can pronounce PROOF and the whole market has it.
Okay, so now that is the selection of unique words, which is really important from a trademarking perspective. But a lot of business people out there don't understand that it's vitally important to trademark protect over and above the fact that you register the company.
To explain it simply, there's two registries that the government have adopted. That's the company names registry and the trademark registry. These are two separate databases that exist, and they don't speak to one another. So you can be Hippo Insurance and have the trademark, but somebody else can have Hippo Insurance, the company name. And that's where we get involved. And companies come to us in order to enforce their trademarks, to stop companies being registered, and vice versa. If they have a company, to try to stop the trademark actually being registered by another third party.
Right. Now, that's an interesting one, because a couple of weeks ago we spoke to Freddie Holt from Brand's Eye, and he was talking in his chat about social media analytics, about understanding when analyzing media interactions, the difference between Mango the airline, Mango the clothing line, Mango a branded drink, and so on. Now there's examples of a whole lot of different brands, and they're all called Mango. How are they able to do that?
Well, trademarks are divided into 45 categories or classes. So you can have Mango Airlines, and there can be a Mango fashion line or a clothing line. And that can, as long as there's not confusion in the marketplace, they can coexist. The big problem comes when there's domain names or websites. So now only one person can have mango.com. Now who gets it? Does the airline get it? Does the clothing retailer get mango.com? Well, the law actually says whoever registered the domain name first will get it, because they both have rights to it, both the fashion retailer and the airline.
So Shane, one of the things it seems to me we often encounter in corporates is people, business people, not having a clear understanding of what they have to register. You spoke about trademarks briefly. we have people saying, please can you register copyright in this for us? And of course one doesn't register copyright as such. Maybe you could talk us through that a little bit.
Well, I think in the IP space, people confuse words and they refer to a patent or a trademark or copyright or domain name or trade secret. And all of these things are distinct, separate elements of intellectual property. So it would depend on what it is and whether that, so if it's a music video, that would fall clearly under copyright. If it is a literary work, a book, you may have an element of copyright to it, but then you may actually call the book something unique, and then you have a trademark element or a brand element to it.
Right. So what we basically have got is the sort of tenets, if you like, of intellectual property law from a protection perspective. There's trademark, there's patents, which we haven't explored yet. There's copyright. What are the pillars that we're looking at? Are those the key pillars?
Those probably together with design rights.
Right. And there's design rights, though, associate to patents.
Exactly. And it would protect the appearance of something.
Yeah.
But trademark law is kind of developed so much so that as a trademark, you could protect a shape, configuration.
Of course, there's the example of Louboutin, who's the shoe designer who successfully trademarked the red underside of the sole contrasting with the dark outer shoe, and achieved that as an international trademark.
Color is protective, and it's obviously unique to certain brands. A good example is MTN and the color yellow. You know, you would clearly associate the color yellow with MTN. So you could go ahead and protect it, but there has to be many years of use and very distinctive.
Timberland in the States successfully trademarking the smell. And yeah, they had people come up with a particular odor that they were pumping through the air conditioning systems in their stores.
It's got to be proved with a number of people recognizing that smell. So would a member of the public walk into that room and go, oh, that's a Timberland shoe I'm smelling over there? Then you can seek protection of that smell.
Now, if you're a business owner and you're thinking, should I be patenting this that I have in my hands? Let's describe that. What are the characteristics of something that demand it to be patented rather than trademarked?
This is always why you'd go see an attorney to specialize in this kind of stuff. So, because there's so much overlap half the time. A lot of the time, you might get something that's patentable, but that you could also get a trademark attached to it. There might be trade secrets attached to it. You might even get a design right attached to it. So they're all very distinctive, and you might need to protect it by way of a number of elements of intellectual property.
People, I think, also tend to have an expectation that anything in intellectual property law and brand protection, trademarks and the like is very expensive business. And therefore, small, young businesses and entrepreneurs tend to avoid it and wait at some later stage to protect their works. But it's not necessarily so.
It's really not hugely costly at all. And also, the advantages that you gain are immense, and the disadvantage of not protecting your trademark or your patent or your design could be disastrous. And in fact, it's one of the first things you should do when you conceive of a new product or a new brand is go and protect it.
Or correct me if I'm wrong, but I know trademarks are territory specific.
Yes.
So you can protect a trademark by trading territory.
Yes, so, and we do that for a number of our clients. If they come to us, they consult with us, and they say, listen, we'd like to protect, the US, China, and we'd go protect each one of those individual countries. The additional problem that global brands have is sometimes you can't actually get protection in some of those countries because somebody else has a legitimate right in let's say, China or Thailand or the US to that. So you might get global brands that might change in certain territories their brand for that particular country.
So all of this work that we do, we start off by identifying the unique attributes of the brand, articulating its principles, formulating that into a strategy, but then we go on and we create names, then we assign identities, logos, and the various trademarkable forms of that brand, and then we take that brand to market. And so there's the legal protection aspect that we obviously need to be considering, but we also need to be considering the way in which we conduct ourselves and take the brand to market to retain conceptual ownership of it, and that's sensible brand protection. So the fundamental thing for all businesses to be considering is protect your brand. Don't just assume you have inherent protection. Look what we've got. We've probably been in the noisiest environment we've ever been in, with or without sugar, and being at a tequila ria, we should certainly be doing this. Gents, thank you very much for your time. See you next time on With or Without Sugar.